Hello, everyone, and welcome back to the lecture series for the preparation of CLAT examination. In this particular lecture series, we've been working to understand that how the legal reasoning portion of your CLAT examination is going to be there, and how a CLAT aspirant is supposed to prepare for the specific subjects that are going to be asked in your examination. In our current lecture series, we are actually working over and understanding what are the important aspects in regards to the legal reasoning portion of your CLAT examination, where which we are dealing with the specific legislations which are often being asked in your examination. The CLAT consortium has described the syllabus of your CLAT legal reasoning portion as there are major subjects with which the CLAT consortium are going to ask you questions, specifically mentioning the constitutional law, the criminal laws, the family laws, which we are discussing from quite some period of time. And then you have law of torts and the contract laws, which we have already studied, which we have understood what are the important aspects of the commercial contracts, how a contract is formed, what are the essentials of the contracts. In the same way, we have discussed about the constitution, which we discussed about what exactly is fundamental rights, fundamental duties, active principles of state policies, and how the union is created, what are the important aspects of the federalism, how the preamble is important, and what exactly is emergency provision, how the amendment takes place, everything which is important in regards to CLAT examination, specifically focusing over the constitution, we have already discussed. Then from quite some time we have been discussing family law, which we have studied about the sources of family law, what exactly are the sources of Hindu law, what are the sources of the Muslim laws, and how the Hindu laws are getting governed, how the Muslim laws are getting governed. So whether there is any specific legislation which we have to understand if at all we are talking about laws which is related to families as such, how the marriage will take place, how if somebody dies, if he leaves the property behind, how the property will be inherited by the other person, what are the provisions which are important to understand if at all somebody wants his property to be devolved to his heirs, or if he has not left any will, then what exactly are the methods through which the property will be inherited. All these things are something that we've been discussing in our lecture series so far. And in today's lecture, we are going to discuss in the same manner the rights of a female Hindu. So in our previous lecture, we have discussed about the inheritance or the succession that takes place in regards to Hindu male. So there is a different provisions altogether when it comes to the Hindu male as well as the Hindu female. So earlier, before the Amendment Act of 2005, specifically mentioning female were not allowed to inherit any property, neither they had any right to not take any share of the property. So they were never considered equal inheritors as compared to the Hindu males. So the sons were allowed to have the property, but on the contrary, the daughters were not allowed to have the property in their name. So this was something which was actually conflicting and obviously against the females. So in order to bring that equality into the preservations and to make sure that both the Hindu female and the male are treated equally, the provisions were changed, and the females were also allowed to inherit the property. So as you can see over the screen, we are talking about the Hindu females and about their property. So the first thing that we need to understand here is that there are two provisions. One which is in regards to Hindu males, and the other one in regards to females. So when we talk about Hindu males, we are referring to Section 8 of the Hindu Succession Act. For your remembrance, I would like to just showcase that section to you so that you can recall that what exactly we are referring to. So the general rules of succession in the case of males, that is something that we have already studied, that how the things will be taking place. We have discussed about the schedule, that there will be 16 relatives or members who will be inheriting the property simultaneously and together. So that is something that we've already studied. Then we studied about what exactly is class 1 higher and class 2 higher in regards to the Hindu males. In the same manner, in today's lecture series, we are going to study about the inheritance or the succession of the property by the female Hindu. So when we talk about female Hindu, the first and the foremost thing that we need to understand here is that the provisions are different in regards to the Hindu female. You cannot say that, okay, if in Hindu male, if the property is being divided in such a manner that there will be class 1 highest and class 2 highest, here it is a little bit different. So we need to understand it, that how a female, the property will be inherited by a female. So the first and the foremost thing that you need to remember, that how a female can get the property. So female can get the property in 3 manners. The property can be acquired by a female in 3 manners. The first is the property from the father. Obviously, before the marriage, the Hindu daughter or the Hindu female has the right of partition and inheritance on the estate that has been acquired by the father. As we have studied in class 1 higher, that the property shall be divided in between the son and the daughter in the same manner. So if hypothetical situation, let's consider that there is one person who has a son and a daughter, and the daughter got married, and after that the father died. So father might have secured a good amount of property. So the property, if we talk about the succession, and if the father has not created any will, the property shall be divided on the basis of interstate succession. So when we talk about interstate succession, then the hierarchy that has to be seen in regards to the section 8 of the Hindu Succession Act, where which the property will be devolving between the son and the daughter, and obviously the widows and other people. But here the reference point is that the daughter will be also getting some property. So the first source of the property that the daughter will be getting is from the father. The second source is obviously the husband, from which he will be getting the property that will be devolved from the husband's side, or if I'll say the in-laws side. Husband and the in-laws. So this is the second source of property for the females. And the third one is her own property. So if the woman is working and she has been independent and she's working by her own self, and if she's acquiring any property, that property will also be considered to be her own property. And it cannot be said that the property which has come from the father she has the limited ownership over the same goes for the husband, that she has the limited ownership. No, it's not like that. Once the property is being given to daughter or wife, or it is a self-acquired property, the ownership of the Hindu female will be absolute. What does that mean? It means that the property will be the sole property of the female who has acquired that property, and that property shall be devolved according to her own will. It is not that somebody can influence her or ask her to provide the property in a certain manner. No, the answer is that the property shall be only in the name of that female Hindu, and the property shall be devolved according to her will only. Okay, so let's read the paragraph. So let's read the section so that it becomes a clear understanding to us that how exactly the provisions of the Hindu Succession Act talks about the property which is in regards to the female Hindu. So it says, section 14, clause 1 says that any property possessed by a female Hindu, whether acquired before or after the commencement of this act, Any property possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held. Okay, shall means it is mandatory. It is not the discretion, but it is a mandatory thing. Even a woman cannot waive off that saying that I don't want to give my property to somebody else. Obviously she can create a will. If she has created a will, then it's fine. But if she hasn't created a will and she dies, then the property shall be understood to be in the name of the female, and it shall be her own property, will be held by her as full owner. So she will be considered as the full owner thereof and not as of a limited owner. So the property that she will be getting from the husband, from the father, and from other sources, whether it is a self-acquired property or it is from father or the husband or it is self-acquired property, all these three type of sources will be considered to be the whole sole property of the female. So please keep in mind, if we are talking here in regards to only Hindu female, don't get confused that it is a general philosophy altogether. No, we are specifically talking about only those females who have religion as Hindu and they are being governed through the Hindu Succession Act. It becomes very important for you to understand that there are different provisions altogether in regards to the Muslim females and there are different provisions altogether in regards to the Hindu females. Here we are discussing about the Hindu females. If we talk about the chronology, first we have studied about the marriages. After understanding the marriages, we have started with the succession, and in the succession earlier we studied about the succession in regards to the Hindu male, and now we are studying succession in regards to Hindu females. So first and foremost, we needed to understand that what property are we talking about in regard to the succession, how the property will be considered, whether the property that she has earned by herself will be considered her own property, whether she has got something from her father will be considered as her own property, or as the husband has given her something will be considered as her own property. So in order to clear the minds, in order to make sure that the property is the property which has been acquired by the female is her own property, section 14 clearly mentions that that property will be the property will be in the full name of the Hindu female and it shall be her full own property. Okay, so let's move in this section, in this subsection, property. Now the question is, what exactly property means here? Are we only talking about the movable property? For example, car, jewelry, etc. Or we are also talking about immovable property. Immovable property. So we need to understand that when we are referring to property, according to the explanation that has been provided under subsection 14, it clearly mentions that the property will include both movable as well as immovable property. Acquired. Now what does the acquired word means here? What does that mean? Acquired means either it is her own property which she has earned, then from the husband's side or from the father's side, or through succession also. Any property which devolved to the Hindu female shall be considered her own property. Okay, so what does it say? Let's just read it out so that we understand it in a better manner. In this subsection, property includes both movable as well as immovable property. I just inform you, acquired by the female Hindu by inheritance, okay, by inheritance or device or at partition or in lieu of maintenance. Okay, so the maintenance also, there is a provision that we are going to discuss in future in regards to maintenance, which is talking about that if a person has married, then it is the duty of that person to make sure that his wife is able to maintain herself and able to live the life and standards which she used to live when she was with her family. So if that is not giving to the wife, she has the right to go to the court and demand for maintenance from the husband. So that is also something that we are going to study for in future. But for your better understanding, maintenance is something that has been given from the husband's side to the wife in order to maintain herself. Maintenance or areas of maintenance or by gift from any person. So now, even if somebody has gifted anything to the female, and that can be anything from anyone. So if somebody, whether be it a relative, whether be it a friend, if somebody has gifted anything to the female, that property will be considered her own property. Okay, let's understand whether a relative or not, before, at, or after. So it is talking about if there is a female and she has been given a property when she was at her father's house, that meaning which she was not married when she was with the father, when she married and she went to the husband's house, this is husband's house, and she got any property from there. So this property, and if she has been working somewhere and she has been earning by herself, then that the amount that she has received from here shall also be her own property, whether a relative or not, before, at, or after her marriage. So during the marriage, a lot of valuables are being offered to the females. So all those valuables which has been offered to the female shall be considered it as her own property. So this shall be considered as her own property. All the three items will be considered as her own property, whether a relative or not, before it or after her marriage, or by her own skills. By her own skills means that she has earned something. Or exertion, or by purchase, she has purchased any property, or by prescription, somebody has prescribed that property to her, or in any other manner whatsoever, and also any such property held by her as Stridhan. Now what is Stridhan here? What is Stridhan, guys? Stridhan is any property which is offered to her. This property includes both movable as well as immovable property. So any property which has been given to her, offered to her during her marriage from husband, in-laws, father, considered as Stridhan, immediately before the commencement of this act, shall be considered to her as her own property. So now what we are trying to understand here is that a female shall have a lot of sources in regards to the property. First, we are trying to understand that all those sources, from whatsoever sources she is getting that property shall be considered to her as her own property. That property will be the whole sole property of that female, who will acquire that either through, as in the form of Stridhan, if somebody has given her as a gift from the father's side, from the in-laws side, whatsoever, the property shall be considered to her own property. But there is an exception to it. And what exactly is that exception has been mentioned under the clause 2 of subsection 14. What is saying? Nothing contained in subsection 1. Subsection 1, which is talking about this, the whole sole property, which says shall apply to any property acquired by way of gift or under a will or any other instrument or any other degree or code of a civil court or under any award wherein the terms of the gift, will or other instrument or the degree, order or award prescribed are restricted state in such property. So meaning which, if somebody when giving the property as gift, specifically mentions or prescribes that in that particular property, the female to whom the property is being devolved will have limited share there. So the property, in that particular property, the female cannot claim that she is the whole sole owner of that property, unlike the property which will be transferred from a husband, which has been given in a form of gift, which is an absolute property. But if this particular thing follows, that somebody gifting shall apply to any property acquired by way of gift or under a will. Somebody has mentioned that in my wholesale property will be devolving to 3 persons, one being my friend, second being my daughter, and third one being that particular female, the Hindu female which we are referring to. But that property shall only be given in such a manner that the property will be utilized by all the 3 people together. So this is a restriction that has been applicable to that particular property. So the female to whom the property has been devolved through a will cannot claim that this is my whole sole property and I am the whole sole owner, because there is a restriction that has been prescribed over that particular property. So this is an exception that you need people to remember when you talk about CLAT examination as such. How is this particular point going to be helpful for you? Because whenever we talk about the exceptions, the exceptions becomes very important whenever there are competitive examinations we are referring to. What happens is that the questions will be put up in such a manner that there is a property in which the female Hindu has got 1/3 of the share. And then in that will, it has been mentioned that the property shall be devolved in such a manner that all the 3 members of the property or the person who are going to acquire the property, the inheritors of that property, will work in such a manner that the property shall be utilized for their own benefits, but on mutual understanding. So now the mutual understanding is giving a restricted approach to the people or to the inheritors of that particular property. So it becomes very important to understand that whether a property is an absolute property or it is a restricted property. So all the things that we have studied in our previous section, which talks about what exactly is the property, here which the property which has been given before, at or after her marriage by her own skill, exertion or purchase or prescription or in the form of gifts whatsoever, shall be considered to be the property of the Hindu female. But it requires an exception also, that if there is any gift by way of will or gift or instruments of a degree that has been passed through a court, which is talking about any maintenance or interim maintenance, etc., that if there is any restriction that has been applicable, then that particular thing cannot be considered as her wholesale property. For example, if during a divorce case, I'll just give you an example for your better understanding. There is a divorce case going on between A and B. Now, B is the female here and A is the male here. Now, A court, after hearing the case, provides a decree or order. Now, what is a decree order? For your better understanding, you can just understand it as a judgment, okay, or a direction which has been passed by the court, okay, nothing else, okay. So, what it is suggesting, that the court said that B shall have right to remain in her matrimonial home. So now this is giving a restrictive right. It is giving a restrictive right to the female Hindu B to have shelter in the house of her matrimonial house, but it is not giving her absolute right to sell that property for her benefits. So this is how there is a difference. In earlier properties whichever she has acquired, it is giving her absolute right. She can use it for her own benefit, she can sell it, she can restructure it whatsoever. But whenever there is restrictive right, it is not absolute, then it is only the partial this is only partially giving her a little bit of right, or if we're talking about there is partial estate or partial acquiring of that property, and there is not absolute property of that particular female. So this is just an exception. So now we have understood that the property of a female can be under the 3 heads, and those 3 heads are from the husband, father, and self-acquired. Okay, now these are the 3 heads. Now the property after acquiring, what happens is that that female dies. Now the female has died. Now how the property of that particular female who has acquired the property through husband, through father, her own property, shall be devolved. So for that better understanding, we need to understand that the property of a female Hindu dying intestate. Now again the question, what is intestate? Without will. Without a will. So if the Hindu female dies without prescribing how the property shall be devolved, her property which she has acquired from a husband, from a father, etc., shall be devolved, has been mentioned under the following rules. The first and the foremost rules devolve to rules set out in section 16. So section 16 is going to provide you the rules how the property shall be devolved, and the preference to whom the property has to be devolved has been mentioned under the said section 15. So section 15 is going to provide you to whom the property shall be devolved. The first and the foremost thing, the property shall be devolved. The first and the foremost person to go get the property are the sons and the daughter. Okay, so let's make a diagram here for your better understanding. So this is okay. This is a woman Y, okay, and she dies. She has a husband, okay. She has a husband and son and daughter, okay. So if she dies without making a will, then whatsoever property has been acquired by Y shall be devolving to son and to daughter. To son and to daughter, to both the people, to both the son and the daughter, the property will be devolved, including the children of any predeceased son or daughter. Now let's take an example. She, the Y, to the female to whom we are referring to in this particular case, she had son and daughter. During her life, during her lifetime, her son died. Okay, her son died, and when he died, he left behind a son, a daughter, and a widow. Okay, now when she will die, okay, the property of the woman Y will be devolving between son and daughter. But now the son has already died before the death of Y. So whatsoever share son might have got if he would have been alive, that share will be devolving between these two people, son and the daughter of the predeceased son, not to the wife. Okay, not to the wife of the son, but to the son and the daughter of the predeceased son. what has been mentioned here, let's read it out for your better understanding. Firstly, upon the sons and daughters. So sons and daughters, including the children of a predeceased son or daughter. So including the children of a predeceased son or daughter. So if son has died, he had a living son and a daughter. Then when she died, and the woman, wife to whom we are referring to, is still present, and she survived her son, and the son had a son and daughter living when she died, then the property which his son would have got had he been alive, that property will be devolving to the son's children. So the son's children will be getting that property. Okay, and to the husband also, and then to the husband. So husband shall also be acquiring that property. Okay, so now this is the first one. So this is the first column, or if we talk about the first preference that will be given. So the son, daughter and the husband are given the topmost ranks in regards to the property, in regards to inheritance of the property which the woman shall give after her demise. If she has not made a will, the property will be devolving to the sons, daughters, including the children of any predeceased sons or daughters, and the husband. So these three people will take the property if these three people are not present. If these three people, the first being the sons and the daughters, including the children of the predeceased son and daughter, and the husband, if these are not present, if they are not present, then to whom the property will be devolved? Then the property will be devolved upon the heirs of the husband. So heirs of the husband means that, for example, there is a woman Y and he had a husband. Okay, husband. Let's make it in such a manner so that it becomes easier. So this is husband and this is wife. So wife here died. Okay, and husband also died. Husband had son, daughter. Okay, and obviously this is the wife, so both of them had the same son and daughter. So now if son and daughter are not present, then to whom the property will be devolved? So if you remember correctly, we have discussed in class in section 8 in regards to the property which has been specifically mentioned in the schedule 1. If you remember the general rules section in case of males, so we have studied about the heirs. So any heir in regards to the husband will be preferred. Any heir of the husband shall be preferred in regards to the property which shall be devolved from the wife's side. So it will include, the husband shall include the heirs of the husband. Heirs of the husband means the mother, okay, shall include the mother. Then obviously the sons, okay, that we have studied in our section 8. All those things will come up handy if sons, daughters, or the husband is not present. So then the property shall be devolved to the heirs of the husband. Now then who shall be given if these people are also not present? If neither the sons and the daughters are present, and neither the husband is present, nor the heirs of the husbands are present, then to whom? Then the property shall be devolved upon the mother and the father. So now the property shall go to the mother and the father, whom is referred after sons, daughters and husband and the heirs of the husband. Then the property shall devolve to mother and father. And if at all mother and father is also not alive, there are chances that after a certain period of time mother and father dies, and then to whom the property shall devolve? Then upon the heirs of the father, the heirs of the father shall receive the property in that particular manner. And if at all the heirs of the father is not present, in the same manner the heirs of the husband is there, in the same manner heirs of the father shall, if they are also not present, then the property shall be devolving to the heirs of the mother. So this is how the chronology, or if I'll say the preference, has been mentioned under section 15 of Hindu Succession Act, which prescribes the manner as to whom the property shall devolve if the woman or if the female Hindu dies, leaving behind her property, which is without a will, or intestate succession has to take place. So this is the preference or order of preference which is being talked about. So if we recall it, then it is talking about the preference. First is son, daughter, husband. Then obviously if some son or daughter has died, then their children. Then the heirs of the husband, heirs of husband. Then what? Then upon, if the husband is not present, heirs of the husband is not present, then father and mother. If father and mother is not present, then the heirs of the father, and lastly upon the heirs of the mother. So this is the order of preference that has to be understood. Now it is giving some exceptions. What is that exception? Let's understand. Notwithstanding anything contained in subsection 1, any property inherited by a female Hindu from a father or mother shall devolve in the absence of son or daughter of the deceased, including the children of any predeceased son and daughter, not upon the other heirs referred to in subsection 1 in the order specified therein, but upon to the heirs of the father. In the very beginning of the lecture, I informed you that there will be the three sources in regards to the female property. One from the husband side, one from the father's side, one from the self-acquired property. So here, if we talk about the property that has been acquired from the father, if we talk about the property that has been acquired from the father, any property inherited by a female Hindu from her father or mother, from her father or mother, shall devolve if the absence of any son and daughter. If the son and daughter is not present, meaning which the class 1, which is a first class, which is going to be referred whenever a female has died, leaving without any will, then the property, if sons and daughters are not present, that property which she has acquired from her husband, from her father and mother, shall not devolve to husband. If at all we are referring to the properties that has been acquired from the father and the mother to the female who has died, and if she has no son and daughter, including the children of a predeceased son and daughter, that property, there are three heads of the property. So the one head which we are referring to the property which she might have acquired from her father or the mother, that property shall not devolve to the husband. But in her absence of the daughter, son, daughter of the predeceased son, that is which obviously mentioned, not upon the other heirs referred to in subsection 1 in order specified therein. No, so it will not go to this. It will not go to clause B, clause C, clause D, clause E. It will not be going there. But what will happen here? Of predation in order specified therein, but upon the heirs of the father. It will directly go to the heirs of the father. So if the property which a woman has died intestate without making a will, and there are properties which there are three sources of her property, one which she has acquired from the father's side, one which she has acquired from the husband's side, and one is her self-acquired property. So we are referring to the property which she has acquired from the father's side. If the children of that woman, the Hindu female who has died, if the children are not present, the son and the daughter are not present, and if the son and the daughter has died before the death of the Hindu female, they are also not present, and if their children are also not present who has died, then the property which she has acquired from the father's side shall not devolve to the husband or to the members who've been mentioned under this particular clause 15. No, it will be devolving directly to the father, to the heirs of the father, as has been mentioned under clause 2 of section 15. Okay, clause 2 of section 15. And in the same manner, it goes to subsection, it goes to the husband side. Husband or her father-in-law shall devolve in the absence of the son and daughter, to whom it shall be given upon the heirs of the husband. So I suppose you are able to understand that what exactly we are referring to when we are talking about the property which shall be devolved to the which shall be devolved if the woman has not been present. If from the father's side, if the property is from the father's side, the property, if the children are not present, it will devolve directly to the heirs of the father. And if it is from the husband's side, the property will, in the absence of the children or the predecessor son children's, then it will be going directly to the heirs of the husband. So this is a small clause which you need to understand when we are referring to the property which is in relation to the females. So now after this we will be moving forward to our section 16, which is talking about order of succession and manner of distribution among the heirs of Hindu female. So the order of succession among their heirs referred to section 15 shall be, and the distribution of the intestate's property among those heirs shall take place according to the following rules. So the rules we are going to study right now. Okay.